Great. I'm going to go ahead and get started. Let me see if I can share my screen. Okay, I'm going to assume that you can hear me okay until I hear otherwise. I'm not sure if my screen sharing is working okay. But before I get started, first of all, I want to thank the AAAS Science, Technology, and Human Rights Group for conference organizers for inviting us to this discussion panel. Presenting today is not just an honor, but also a chance for us to hear feedback and ideas from the community of scientists outside of genetics and human rights groups from around the world. I've been hearing a lot the last hour or so about the bridges, and we're going to talk today about a group that we have organized over the last few months called DNA Bridge, and I'm looking forward to hearing people's thoughts. I'm going to moderate this session, and we have 4 panelists that will be joining us. In terms of disclosures, none of the presenters have any disclosures except Richard Selden, who founded the rapid DNA company Andy, although his presentation today is only related to his voluntary efforts and affiliation with DNA Bridge. So in my research on various non-medical DNA applications, we are learning that context matters. There are 5 contexts that we like to talk about related to immigration in which DNA is used. First is the commercial uses of genetic tests to verify family relationships. If you Google immigration DNA, the majority of the hits will be the commercial offerings of DNA tests in this capacity. This is usually for family petitions of people coming to the United States, and sometimes it is required in certain circumstances. Second is the collection of family reference samples, family reference sample DNA data in the efforts to identify missing migrants. This is also a topic that has been of interest with AAAS and the Human Rights Group, but not one that we'll be covering today. Third is in this middle part is the one we'll be focusing on today. This is the use of DNA tests to reunify families that have been separated by the government during migration. And we'll talk further about this. But related is fourth, the use of rapid DNA testing at the border entry points to verify claimed relationships. So this is the government-driven efforts to detect supposed fraudulent relationships. And then fifth is the collection of DNA for the criminal database in the United States from migrant detainees. So for your reference, we recently published a paper on this, on several of these contexts. That helped to outline the differences. So back in 2018, the world was shocked to hear of the migrant family separation policy that began as a pilot in 2017 and extended through 2018. This was the zero tolerance policy that meant that all border crossers were criminally charged, resulting in the separation of minor children from their families. This policy was reversed by the end of June 2018, but not before thousands of families had been separated. With many of those parents were deported, many of them lost touch with their children who remained in the United States in foster care or in other family situations. In July 2018, the US government, in efforts to try to reunify those families that had been separated, called for the use of DNA testing to assist with the reunification of those that had been wrongfully separated. This prompted backlash of the community as the government was, as an intrusive effort of the US government. It also was not well designed in that they were using one-to-one DNA testing through commercial laboratories, private laboratories, that could potentially penalize the non-genetic families if they were found to not be related, which would prolong the separations of those families, and it could also reveal some private information about these families by this one-to-one testing. Fast forward a couple years to 2020, and as President Biden was debating then President Trump in October 2020, he mentioned the 545 children that still remain separated at the US border. This was a shock to me. I think it was a shock to many. That despite the judge ordered requirement to promptly reunite families back in 2018, they had not. Hundreds still remain, maybe thousands still remain separated and difficult to track down. This news prompted some of us to convene, led by Dr. Svetas backing up to now, these families still remain separated as evidenced by this coverage last week in 60 Minutes. So this prompted several of us to convene, led by Dr. Svetas of the University of Minnesota, who's a pediatrician interested in protecting the health and human rights of these traumatized children, and also with a Physician for Human Rights, a group that has long been working with the AAAS, in fact, and working on migrant family rights. So from November 2020 to about April 2021, we had many conversations, and emerging from that was this DNA Bridge group, a voluntary group of expert volunteers from human rights and science and pediatricians and trauma-informed advocates and attorneys to work together to try to come up with a way to harness the power of DNA data, of the genetic sciences, to be able to advantage these families that have long been separated, but in ways that would not harm them in the way that prior efforts might have, especially in the 2018 proposals. So it was clear to we experts that if DNA could be used for these families, then it should be used. Moreover, it's clear that had there been a strategy back in 2018 to help track these families, then perhaps we wouldn't be in this situation in the first place. And it's clear that separations are going to continue as we see families are separated over coming from Afghanistan right now. Families were separated from coming from Syria a couple years ago. And we have hundreds of thousands of children crossing the border into the United States unaccompanied continuously. So we need better tools, we need better systems, and we need if we're going to use science tools, they need to be outside of the government with data privacy protections. So this is how we formed as a voluntary group. Perhaps it will transition to a more formalized NGO in the coming time period. And we're trying to figure out whether it needs to be operational or not. But I have invited 4 of the members to present today. First off, Liz Barnare, who is a pediatrician at UCLA. She's going to talk to you about the privacy or the needs of the children and trauma-informed practices for reunification. Then we're going to hear from Richard Selden about the DNA testing strategy that we are proposing and how it's designed. Dr. Wagner, who is a attorney and expert in all things genetics and policy, will talk about the legal structures and the current legal efforts, especially in the United States, for the reunification. And then Dr. White will talk to us about the human rights perspectives around the activities of DNA Bridge. I'll transition to the 4 panelists. So Dr. Bernier will take it from here.
Thank you, Sarah. That was a great introduction. Thank you, everybody. It's an honor to be here. And yes, we want you to hear what we're saying. We want your feedback, and we want to help build these tools. So I'm going to talk about some of the numbers Sarah went over in terms of the disappearances and the child separations. Sarah, are you able to slide share? Okay. So as Sarah explained, under the Trump administration's zero tolerance policy from 2017 to 2019, following numbers that are available through a lawsuit, that a class action lawsuit by the ACLU, we know that there were 5,512 total separations. And of those, about 2,800 were determined to be resolved and 1,500 were considered to be justified. And the ACLU is attempting to locate and put families back together for 1,198. And the numbers that we have from July 2020, there were 532 parents contacted, and for 666 children, no parents were contacted. At the next time point that's available, January 2021, there were 587 families contacted, still 611 had no contacts. And of the 611, 392 had been deported. That's the yellow. Blue, the 201 of the parents were in the United States. And the red are the children whose location is unknown, the children that essentially were lost, so about 18. And what you can see is if you look at the most recent numbers from September 2021, there still are finding children, but the rate is slowing down. There's still 303 children where no parent was contacted, and of these, 12 children are still lost. Next slide, please. So what we really want to focus on is the role of DNA in supporting the reunifications of the migrant children with their families. And in order to take a trauma-informed approach that really supports the best interest of the child, the team of geneticists, human rights advocates, physicians, we really need to understand the appropriate use of DNA. So the way that I think about reunification or reunifying a family is that it is a process that begins with the search, and the role of DNA is the identification. It is that making that match of using a database and saying this child matches this biological relative, and then what happens after that is really what we've put forth is really up to the agency of the family. It's very contextual in terms of whether the families actually choose to meet in person. There's immigration implications, legal implications in the context of immigration. This is a photo from a recent 60 Minutes piece, and this is showing a biological mother from El Salvador reuniting with her two sons. They were one of the first children separated under the Trump administration's zero tolerance policy. And she's in an airport in the United States and meeting her granddaughter for the first time. And so this is the moment of reunion. And our job, what we want to tell the world is that it's DNA can help with the identification. And as soon as that identification is made and it's shared with the family, what we know from research is that it immediately resolves a lot of the pain. And then it restores families' agency to have decisions about when and how they might reunite. So now I'm going to pass it over to Richard to talk to us about how we might be able to do that. Thank you.
Thank you, Liz. DNA Bridge published an article in Science a few months ago that describes our overall approach to using DNA to help reunify separated children and their families. Now, in order to apply essentially any technology to solve a societal problem, it's important to understand how the technology works and its potential benefits and unintended risks. Armed with this understanding, it's then possible to make informed decisions on how best to apply the technology or whether or not it should be applied at all. The use of DNA to reunify families brings up plenty of questions about DNA technology. Now, it's important to note there are many, many DNA technologies. We want to discuss only one of those DNA technologies, really the foundation for the DNA bridge proposals, and that's called DNA fingerprinting. I know it's early, so there's only going to be one quick slide on molecular biology, but I think it's important. The 6 billion letters of the human genome are organized into 46 chromosomes. And one chromosomal feature is the basis for DNA fingerprinting. That feature is called STRs, or short tandem repeats. And these repeats are found throughout the human genome, and they're composed of short repeated sequences of DNA that typically differ in size from person to person. And you can see on the top of the slide schematically an STR region of the chromosome. You can see indicated 4 of the DNA letters or bases, A, T, and G, are repeated several times, 7 times on the top chromosome and 8 times on the bottom. And the number of repeats at a given STR site on a chromosome is characteristic of an individual. And since humans have 2 sets of chromosomes, one from each biological parent, we inherit our short tandem repeats from our parents. By analyzing a set of about 20 STR regions on the chromosome, it's straightforward to determine biological relationships. Now, let's consider what STRs can and can't do. Next slide, please. So first, it's important to say what this kind of DNA data can't do. So the DNA fingerprint data has no useful information on medical or behavioral, past, present, or future of an individual. It has no information on the appearance of an individual. It has no useful information on the geographic origin or the current location of an individual. There is minimal information in a DNA fingerprint. It's very important to understand this. A DNA fingerprint contains less than 100 millionth of the information in the human genome. So to put that in perspective, if you have a stack of 40 copies of War and Peace, that's about 100 million characters. So by analogy, the information content of a DNA fingerprint compared to the entire human genome is about the same as one letter is to that stack of 40 copies of War and Peace. Now, Tolstoy was a great writer, but even he couldn't do much character development with a single letter. Next slide, please. So perfect. For family reunification, this very small amount of information in a DNA fingerprint can essentially always allow biological parent-child relationships to be determined, and usually sibling relationships to be determined. Sometimes it'll work for more distant relationships for grandparent and grandchild and half-sibling. It's important to note that they are never useful in assessing adoptions by non-biological parents. So DNA fingerprints based on short tandem repeats are incredibly useful in reuniting most, but not all families. So if DNA fingerprints contain so little information, yet are so useful to help families, why do we worry about protecting the data of migrant family members seeking to be reunified? And the reason is that DNA databases, as Sarah mentioned, are also used by law enforcement agencies throughout the world. And we believe that a parent that voluntarily provides their DNA fingerprint to find a child has the right to privacy and to protect unauthorized use of their DNA information. So before I go to my last slide, it's important to acknowledge the limitations of DNA fingerprinting. It's amazing technology, but not universally applicable. Next slide, please. No technology, including DNA fingerprinting analysis, can reunite all families, but their inherent limitations are not adequate justification for avoiding their use to facilitate prompt reunification of migrant children and their parents. Next slide. How can we protect the DNA data? How can we make this all work? So our strategy is quite straightforward. The critical principle is that governments will not have access to the DNA data that's used for familial identification. Parents searching for their children can donate cheek swabs, so for example, to a Central American-based NGO or to legal representatives. These organizations can generate the DNA fingerprint in a lab or outside the lab using rapid DNA instruments. They can then place the de-identified DNA fingerprints in a database held by an intergovernmental organization. That intergovernmental organization can protect the data. The International Commission on Missing Persons, based in the Netherlands, is one such organization, and they're an important part of DNA Bridge. The separated children being held in the United States will also get DNA fingerprints generated by US NGOs or legal representatives, who then also will forward the de-identified data to ICMP. Our vision is that ICMP will then search the migrant children DNA data against the ICMP parental database, not a one-to-one search, a database-to-database search. And when ICMP identifies a match, they will then notify the NGO that the parents worked with and the NGO that the separated migrant children worked with to enable ultimately trauma-informed reunification. So in order to make this work, we need the US government to be willing to work with NGOs on reunification. We think this is a reasonable request that serves a humanitarian purpose. So in sum, DNA can enable reunification in most cases, and it can be done while protecting the privacy and respecting the agency of family members. And we're really excited to move forward. Thank you. I'd like to hand things over to Dr. Wagner.
Thanks. So I'm going to talk a little bit about what's been happening in the past few months regarding reunifying these separated families. So on February 2nd, you all might recall, President Biden signed an executive order establishing an interagency task force for family unification. That was to serve three functions. First and foremost, to identify all children separated from their families, to facilitate their reunification, and then thirdly, to provide recommendations for other types of support that would be needed. The task force is led by Secretaries of Homeland Security, Health and Human Services, and State, along with the Attorney General, Merrick Garland. The first progress report that we were able to see from this task force came out June 2nd, detailing what they have been doing for the first 120 days. In that report, they did mention that they had a reunification process that was in place, and that importantly for our purposes, they made no mention of even having considered DNA technologies or use of DNA data in that process. Now, per the terms of the executive order, these progress reports are now due every 60 days. So we should expect updates on a regular basis. The first of these interim progress reports came issued August 1st. It was made available to the public August 26th. So there's a lag there. But again, no mention of DNA, no mention of DNA data being used or considered. We've been anxiously awaiting the next interim progress report, and that was released online just yesterday, even though it's dated September 30th. And again, no mention of DNA technologies having been considered, no mention of DNA data being used to help expedite the reunifications of these family members. Now, this report from the most recent progress report did indicate some of the steps that they are taking, including the new website that they launched on September 13th called together.gov, and there's a Spanish counterpart. And I'll detail that a little bit more momentarily. But the task force cautioned in that report that we should expect those numbers for how many children are still not with their family members to go up and down, and that this fluctuation is not indicative of a lack of progress. We shouldn't interpret it that way. Rather, it's just indicative of the data challenges that are involved. Now, I'm not sure how much of a comfort that will be to the human beings that are stuck in this process and not with their family members. I don't think that's any consolation at all. Before this last progress report, however, there was a very important privacy impact assessment that was issued on September 8th. And this relates specifically to the data gathering systems and processes that the Family Reunification Task Force has underway. Importantly there, the PIA acknowledged, quote, because no comprehensive interagency system was in place at the time to track separated parents and their minor children, and because initial identifications occurred through litigation prior to the establishment of the task force and the Family Reunification Task Force's involvement, pinpointing the best data sets has proven challenging. No kidding. We hope that this will be a call to action to prevent this from happening again. In any case, the PIA allows us to have some sense as to where they are getting their data from. They're getting it from at least 6 different sources. They start with the data on the children that Department of Health and Human Services has for children that are in their custody. Department of Homeland Security then reviews that data to make their determination based on their data as to whether those children were separated from family members or unaccompanied when they were encountered. And then there's this streamlined data set that is made available for task force purposes on a need-to-know basis. Okay, and then of course they have this new website for self-disclosed information from together.gov where individual family members can come forward and provide details in the hopes that there might be a reunification eligibility determination. Now that PIA walks through the fair information practice principles, it walks through the risks that they think are involved with the data that they are collecting, doesn't mention the possibility of DNA data being involved in this process, or even that it was considered. And I'll mention that there is a disclaimer on that website about information sharing that clarifies that any self-disclosed information can be shared, may be shared with national security agencies, with law enforcement agencies, including ICE and Border Patrol. So this could be used for other purposes, although it's specified that it cannot be used for removal. Now, use of the website also involves a waiver of confidentiality protections that might otherwise be applicable to these individuals. Now, others in this panel had mentioned the importance of lawsuits, right? The ACLU brought action in 2018 to put pressure to have these issues corrected, to stop the family separations. And without them, who knows where we would be in terms of family reunifications. As an aside, in terms of this litigation, Mrs. L versus ICE, whose settlement implementation is still ongoing, while DNA technologies continue to be omitted from the publications coming from the task force and seem to be excluded from the family reunification process that they have underway, we have learned that the US is continuing to impose the burdens of DNA technologies and testing at the border, some with potential family separation consequences, and they're relying upon this litigation as their justification of authority to do so. While the task force has a tremendously complicated mission that I think we all will acknowledge, and they have made some progress, we need to ask why progress is not happening more quickly and why not all of the tools available to us are being considered or discussed publicly. Next slide, please. Now, we need to highlight the human rights that are violated or at least implicated by what is happening with the forced separations and now the ongoing separations that have not been brought to conclusion. So this slide outlines several of the human rights instruments and notes some of the provisions in those instruments that we should signal. While the US has not signed and ratified all of these instruments, its obligations to the world are pretty clear. They have the right to protect the protection of the family unit, the right of children not to be punished for the status and the actions of their parents or the adults that are with them, the right to the highest attainable standard of physical and mental health, including provision of necessary steps, quote, for the healthy development of the child. We have the right to share not just the burdens of genetic technologies, but also their benefits, as well as the rights to privacy and data protection. Next slide, please. Now, As was mentioned previously, we're not advocating for any and all use of genetic technologies. We are very specifically advocating for a privacy-preserving approach that involves a database-to-database comparison rather than one-to-one comparisons of individuals. This limits the inferences that can be made and helps preserve the privacy of those individuals and family members until they're ready to disclose extra information with others, including NGOs, including the task force if they wish. We also need to have intergovernmental organizations involved. This is important for the data management purposes. IGOs, unlike NGOs, are treaty-based organizations that have privileges and immunities that allow them to operate outside of the reach of the nation governments. They're independent. And unlike NGOs, IGOs would be free from the risk of governmental agencies like ICE seizing data and information, potentially with or without a subpoena, about the separated family members and using it in ways not in their best interests, such as deportation or prosecution of crimes. But we acknowledge that robust protocols for privacy, confidentiality, and data security must be established, right? Endeavor is not research. So NIH certificates of confidentiality would not be available readily to shield the identities of these individuals and prevent unwanted disclosure of the information. Data transfers involving the US are notoriously complicated right now, given the lax protections that are in place and the pervasive government surveillance laws that the international community has acknowledged. We're aware that biometrics of any kind in humanitarian contexts are difficult and that it shouldn't be used without careful consideration of what's at stake. But quite frankly, in this particular situation, we cannot allow ourselves to view the possible risks of privacy harms if DNA were to be used in this way to expedite family reunifications without also acknowledging that every day these family members remain separated, there are actual harms compounding for these children as well as their family members. And finally, we acknowledge this might not be a perfect solution. We might not have all the answers, particularly when it comes to the data privacy and cybersecurity aspects. But that's exactly why we would invite other experts to join us in this effort so that a responsible approach is developed and available for future use. And now I'll turn it over to Tom White.
Okay, thank you, Jen. DNA testing has been successfully used to identify remains from war crimes and mass disasters, parents, or enforced disappearances with their biological family, especially in Argentina, Guatemala, Honduras, and El Salvador. Non-government organizations in these countries have established informed consent processes for children, their biological relatives, and adoptive parents, and also to provide social support for family reunifications. Some of the separated children's parents were deported to these countries. Some of these scenarios were to identify dead or missing and presumed deceased persons, in contrast to efforts to reunify families where the parents are presumed alive and time is of the essence since the children are suffering. Next slide, please. In addition to the hundreds of children still separated from their families at the border during the Trump administration, many of the unaccompanied minors detained during the recent surge of migrants are fleeing government repression and violence in Guatemala, Honduras, and El Salvador, where the United States has a long history of training and supporting military coups and governments responsible for atrocities against their citizens. Family units are also migrating in unprecedented numbers, with many coming from countries other than those in the Northern Triangle of Central America. All of these family units are at risk of separations to the extent that they continue to be under U.S. authority, and where the government's DNA testing at the border is continuing with the objective of detecting fraud. Next slide, please. As climate change, government repression and violence continue, migration may become to be seen as the only option for safety. not only at the US border, but worldwide. So there is an increasing need for permanent global DNA testing processes to identify and support families that become separated during their migrations. The numbers this year at the US border are 3 or 4 times greater than last year. And this is indeed a crisis as families are suffering and many migrants may die in their efforts. Next slide, please. As Richard has described, DNA Bridge has proposed a framework for DNA testing based on successful identification and reunification practices by the International Commission on Missing Persons and several non-governmental organizations in Latin America. These concepts are at the core of the proposed strategy, which might not be perfect, but they are our attempt to develop a process that is better than existing policies, and one that embraces the use of validated scientific tools and that place the health, humanitarian, and human rights needs of families ahead of government data collection. Thank you.
So I'm going to take over right briefly before we open it up for questions. We're trying to save as much time as possible for Q&A from those in the audience. First, thanks to the 4 that were put on the spot to present on DNA Bridge. We are a large group. We meet monthly and we have conversations with 15, 20 different people on a Zoom call, all doing this voluntarily, like I said before, and all trying to think through and scratch our heads as to how better to respond to the existing crisis of migration, the past crises of the separations, and the urgency that these children are currently suffering as they don't have access to their families. So I think the question we have is how can we do better? What are the next steps? What is the cost of not doing anything? And is not doing anything, is that part of the being complicit with the keeping families apart? So at the risk of being an advocate or sounding too pro-genetic or pro-gene testing, we are very aware and work with Physicians for Human Rights and other groups in acknowledging the past misuses of genetic information. And that is the core of our focus, is that we know that there are strategies that can better protect genetic data. We know that there are consent processes that have been developed for disaster victim strategies. And there are DNA-led strategies now in disaster victim identification to minimize the time that it takes to identify deceased people after a disaster. And we're asking that we take these things we have learned over the last decade or more in seeing genetic science being applied in humanitarian and human rights contexts, and see if we can develop a strategy that's a global strategy outside of government to advantage families. So again, I'll leave this right here for a moment, and then I'm going to turn off my the PowerPoint so that I can see the people in the room and see the chat box. But we are a large consortium of individuals at this time. Perhaps we will become an NGO and become a different structure slightly. But our effort will be to see whether we can bridge the gaps that we're seeing and the lack of activity that we're seeing in using science and DNA data responsibly. Stop sharing. So, and to kick off the Q&A, Liz, I wanted to bring it back to you as you were talking about the need for trauma-informed protocols in reunification, and maybe you can tell us a little bit more about what trauma-informed protocols look like and what a reunification should look like.
Sure. So I have a helper here to remind us that we're talking about children. This is the face of a 7-year-old child who needs to put on his clothes for school. And what we are talking about is supporting children's development, and the comments that were made about everyday mattering and the compounding harms of keeping families separated. We're right on. So what trauma informed means is that there's several different principles, but what it really boils down to is that you acknowledge the trauma that people have been experienced, and you approach them with kindness. And an important aspect of what we're doing in the role of DNA is specifically you try to avoid re-triggering trauma. And so it's very important that families have agency. And as I was saying about the DNA identification then gives families the option for reunion. It's the restoring of that energy, of that agency, that is central to applying a trauma-informed approach.
Maybe I can put it to all of you, this next question, which is, why is DNA not being used now? What do we think the barriers are to using genetic data in the ways that have been proposed by DNA Bridge?
I can start. I think there are a few main reasons. I think the first is misconceptions about what DNA actually can do. And there are so many different kinds of DNA technology, and I think those all get blended together. And I think people who are concerned and who want to help families are worried that the DNA information might say something about the health or the potential for illness, and could be somehow used against them. And that misunderstanding creates fear. I think by explaining that the information that we're using for reunification is not any of that is important. I think a second major reason, and others on the panel can comment, has to do with privacy concerns and really mistrust of government. So, a parent who's had their child separated from them is probably not very trustful of the government. And then to provide DNA information, especially not truly understanding what could be done with it, I think also leads to people who wish they could donate their own DNA to decide against it. There are other reasons too, but I think those are the two that I think are the major ones.
I'll just jump in and say I agree with those comments. I think a lot of it has to do with optics and misunderstanding of the different types of technologies and what we're actually talking about here, right? So when you're using a database to database comparison, what's interesting about that is if you don't have a match, what that tells you, it doesn't tell you much at all. There aren't opportunities for repercussions in the same way that there might be if we're doing one-to-one comparisons, right? The absence would just mean that there doesn't seem to be a close genetic relatives DNA data in that database. And so I think that's important to keep in mind. But I also think that it is just broader, the socio-political environment that we're in, criticisms of biometrics and DNA generally, including in humanitarian contexts, and the potential for misuse and unauthorized access, perhaps even the overuse of biometrics in these kinds of situations. But I think that argument or that justification is rather empty when we think about the fact that the US government is using DNA technologies in other situations, not for their benefit. Right. And so I think we have to ask that question. It's not a matter of not using DNA, because they are using DNA in a lot of different contexts. So why not in this particular narrow context where you wouldn't have to keep the DNA sample, you wouldn't necessarily even need to keep the DNA data. It's just a matter of finding a way to expedite those connections. And I just want this conversation to be had in the open. With the people, the people who have the most access to the information about what is and is not feasible with the international community and the cooperation of our government.
One question we have from the audience is, do we know the error rates for the type of DNA test being discussed used? And maybe add to that, what do we mean by one-to-one testing versus database testing? How do the error rates play into those different scenarios?
So I could take the first part on error rates. For a parent-child relationship, um, the error rate is incredibly low. So if you have a biological parent and biological child, the likelihood of the relationship being parent-child is generally at 99 point and about 6 or 7, 9%. So 99.9999%. And so there are very, very rare occasions where you might not be able to tell, but it's almost infinitesimally small. For sibling relationships, it's not so much an error rate, it's a probability. Usually about 80 or 90% of the time, you can identify a sibling relationship with a confidence of greater than 99.5%. So the error rates are very, very low with this kind of technology.
One of you want to tackle the how is one-to-one testing different from this database strategy that DNA Bridge is talking about?
Okay, I will. So the error rates in a one-to-one and in a database strategy are the same. In the end, there's no difference. The difference is that in a one-to-one, you say you have this person and that person, and you're saying something about those two people. And if there's not a match, it's saying something about those two people, something that really those people might not want said. So, for example, in the case of an adopted parent, a non-biological adopted parent, there's not going to be a match. In a database to database, you just don't see that match pop up. And so it just further protects the people in both databases, protects their privacy.
Um, Keeping Richard on the spot, your presentation, you were saying that STRs will detect parent-child relationships, which is the majority of those separated during 2017, 2018, and that it might help with sibling relationships. But what if the relationships are not parent-child or sibling? What if they are aunts, uncles, or more distant related? What kind of tools can be used for separated families in those scenarios?
So I think that STR analysis will work for something like 80 or 90% of the separated children today. One thing that's really important is to acknowledge there will be cases, more distant relationships, avuncular relationships, grandchild relationships, distant cousin relationships that can't be looked at. And sometimes people say, then you shouldn't do it. And my answer to that is if we can help 80 or 90% with this technology, we should move forward. Think about it. If there was a drug developed today that cured 80 or 90% of cancer, nobody would say don't use it because it doesn't get everybody. So we want to get the vast majority of people. But then you're right, Sarah, and there are cases where that won't work. So there are other technologies that are out there. Some of them are based on sequencing the entire genome or doing SNP analysis, looking at a large number, thousands of letters scattered across the genome. And those technologies can work, and they do work. Our view has been that those technologies also bring in other questions because some of those other technologies can say something, for example, about the health of an individual. And so our view is we can start with technologies that really provide no information on the individual, STR technology, try and help 80 or 90%, establish the protocols and approaches to protect privacy and agency. And then if we can show that this is successful, and I think we will, then we can consider expanding to other technologies. If we try to do everything at once, I think we won't get anything done. But if we focus on kind of the easiest, most straightforward, and let's get 80 or 90% of those kids helped, then we can move on in a very carefully considered way.
Tom and Liz, it's common for consent processes to be a part of the DNA testing, whether it's for disaster victim or for research testing or in a clinic. To what extent in these human rights and humanitarian contexts, how does consent play into the process for these families? Can't hear you, Tom. Tom, I can't hear you.
Should I go ahead and answer for now? Okay, well, that is a great question, Sarah, and it's a complicated one. I'd love to hear Tom's thoughts also, but I'm happy to fill in. So in the previous human rights context, Tom raised the example of El Salvador working to find its disappeared children. Families come forward and they say, please help us find our children. Our children were taken from us. Our children is missing. And we're envisioning that with the DNA Bridge database approach, it would work similarly, that families would come forward and say, please help us find our children. And one issue that we do need to work out is on the side of the children, what will be appropriate consent procedures for a 4-year-old versus for a 15-year-old. And so we want to work with experts with affected families to really figure out what people feel would be most ethical and most appropriate. I do want to spend a moment, if it's okay, because I was a little bit distracted earlier, talking a bit more about the trauma-informed approach and the heart of the issue. So what we are talking about is parent-child separation. And I think it's really important that we don't underestimate the importance of the parent-child bond, which my son came to illustrate us. And if you notice, he was even kind of rubbing his face on me, which he was probably stimulating oxytocin, so what scientifically, when families are separated, on a psychological level, especially in the context which some of these families from Central America may be experiencing, is this ambiguous loss of that very intense pain of not knowing those numbers in red that I showed you, the 12, the 18-year-old children that are lost. Those parents might be in the situation of not even knowing whether their children survived. And that's something that a database can help solve. It's something that organizations in Argentina, in Guatemala, and El Salvador have done effectively. And so with consent, we think very much that families would come forward and would be very interested. And on a biological level, in terms of child development, there are harms at so many different levels. There's a toxic stress that accumulates and likely contributes to physical and mental illness all the way into adulthood. So every day matters, and the consent issues are challenging. But if you put together thoughtful experts, involved families to really focus on what is the best interest of the child, I think we can figure it out.
Do we have Tom's audio yet? Apparently, no audio from Tom yet. We'll keep working on that and then circle back to him. A question came from the audience about from Diana asking, can you elaborate on how a database strategy might protect families from revelation of say, misattributed paternity?
So I'll try to take a first pass at answering this. So the simple way to answer is to say what we have envisioned is that both of these databases would be de-identified, right? So the benefit is that you have a child database that has the separated children, and then you get the DNA fingerprint or the DNA profile. That profile is in a database with the other children's profiles. So you're not talking about one individual child, you're talking about all the children at the same time. On the other side, the other database would be parents and family members and their de-identified DNA profiles. And so again, the comparison is all of them collectively. So when the comparison is done database to database, it's not about individual parent-child relationships. It's just saying, out of all of these people, are there family relationships there that we can try to connect whomever is helping with the individuals in each database, right? So the trusted partners working with the children, the trusted partners working with the family members. At that point, can we connect them? Do they feel comfortable coming forward with information to actually facilitate that reunification? So misattributed paternity is not something that you would see from this database to database comparison.
I think we might have Tom back. Tom, can you hear us?
Yes, I can. I'm sorry, but there's
Great.
feedback, of course, from my own microphone.
Okay, well, we don't hear the feedback, so if
Oh, you
you
don't? Okay.
ignore it yourself, we'd love to hear your thoughts about consent
Okay.
processes.
So on the informed consent, I want to use examples from Pro Búsqueda in El Salvador and the International Commission on Missing Persons. These organizations have developed informed consent processes for children, some of whom are now adults, for their biological relatives and for adoptive, or in some cases, appropriative parents. The foundational principles are that informed consent is always affirmative, always conducted in person by someone fluent in the child's relative's primary language, and most important, that informed consent is a process rather than a one-time event with the opportunity for reaffirmation or withdrawal. For minor children, there is still work to be done on developing a widely acceptable informed consent process. And Dr. Barnett described the informed consent she's used in some studies of children. And perhaps some of the people attending this session can suggest ideas from their experience. But we must keep in mind that the hypothetical harm to a child from not giving informed consent has to be weighed against the actual harm of delaying reunification with their family.
That's a great answer, and I really appreciate your thoughts on that, weighing out the risks and harms, the harm of doing nothing and the risks to these families. Bring it back to risks. Jen, you were talking about the database and talking about the database strategy. You have a database of migrant children and a database of their parents that are seeking their children. That sounds like a lot of really sensitive data and data that could be not easily, but could be wanted by the governments to do harms to those families, or to deport families, or to track down potential criminals. Certainly some families are bad actors. Certainly some of them are criminals smuggling drugs or whatever the scenario might be. Can you talk to us a little bit more about how best to protect that kind of sensitive data?
Right. So, yeah, I mean, I think that's the elephant in the room, right? Is how do we protect the data? How do we make sure that the privacy and cybersecurity protections are there? How do we make sure that there's trust inherently built into this system and this process? So I mentioned this isn't research. So NIH certificates of confidentiality aren't available, which otherwise provide some protection. The reason we're so concerned is this notion of the third party doctrine. That's a legal doctrine that basically says once you give information to a third party, generally speaking, you lose your reasonable expectation of privacy in that information. And so the same Fourth Amendment protections from unreasonable search and seizures don't really apply to you. It doesn't protect you anymore. There was a relatively recent court decision in Carpenter, US versus Carpenter, where they had an opportunity to evaluate this doctrine and see kind of the boundaries. How far does that go? And it depends on the type of data. It depends on how automated that data collection process is, how voluntary you can be in that delivery of the information to the third party, and also like the nature of how broad and deep does that information go? What can you learn from it? Well, we already learned that the genetic information we're talking about in the way that we've envisioned a DNA bridge is very, very limited, for one. So we're trying to minimize that potential risk. But you still have this danger that the government, law enforcement agencies, national security agencies could access that information, whatever information that is, from a third party. That's one of the reasons why having intergovernmental organizations involved rather than just NGOs is so important, because they're a treaty-based organization and they can stand up and say, no, you don't get access to this information. This is a treaty. It has the backing of the highest possible law. So you can't get around that. You can't circumvent that in the way you might be able to in this other way. And then the other piece that I'll add on is one of the aspects we've been talking about in terms of responsible data management involves keeping the data local with those trusted groups, and so not transferring the data as much as possible, so that it also reduces the opportunities for misuse and unauthorized or unexpected access.
So Jen, that was really helpful. And I love that we're partnering, because you all know so many things I don't know. And if I could just clarify for our audience, what we're proposing is that the intergovernmental organizations would have the sensitive data, would have the DNA database, and then we would be relying on NGOs on the ground in Central America and the United States to work with the families with the identifiable information once we've passed on, the IGO has passed on the information, then a match has been made.
Yes, very important clarification, and I'm glad you made it.
And I'm sure that many listeners will be concerned about the next steps in the process, the actual reunification. And there, I think we have to look to the experience in Argentina and El Salvador, which have now decades of experience in these very difficult reunification processes. And so we can learn from what they've already done with these types of reunifications.
Yeah, and I'm sorry to keep coming back to this, but I have to keep coming back to the fact that the US government uses DNA in other contexts. They use it to prosecute fraud. They use it to turn people away at the border, potentially. So my concern is, why are we not thinking about using it to find the family members of the 300 and some odd children for whom they have no contact information whatsoever? Right? There is no other way to identify those family members. There is no other way right now to help them reestablish their own identities, to which they have a human right to, right? So I just want us to think constantly about, this is not the question of using DNA or nothing. We have to do something, right? So let's have this conversation. Let's talk about what the challenges are and find a way forward, even if that's an imperfect solution.
If I may add on that also, so we are focusing on the family separated in the Trump administration's zero tolerance policy, but as Sarah mentioned, this has other applicability. So I think it was in March, there was something like 18,000 unaccompanied minors, children that came to the border without adult caregivers. I was one of the many pediatricians taking care of them in the emergency shelters. And these children are so young, so vulnerable. The younger they are, the less likely it's going to be that they're able to give information so that their family, their biological or caregivers can be located. Having spent time in El Salvador, I remember one of the things I asked people when somebody begins their migration journey, which can take weeks and it can take months, even over a year, how do you know that somebody hasn't made it? And the answer that they said to me, quite simply, almost, as if it was a dumb question, you just don't hear from them. And so one of the things that, if a system was set up, something that could proactively happen is families could come forward before a child or a family member makes the journey. And so like we need, as Jen is saying, we need to constantly be thinking about DNA and thinking about how it can help promote human rights, not just reactively, but proactively.
There's a question from the chat, I think, that says, do you expect the US government to ask to verify using ask to verify any claims of relationships using DNA data before allowing the reunifications to happen?
Something else I think I want to clarify, and then others can feel to jump in on the technical aspect. DNA is one piece of the information. So when organizations in the past have used DNA, you use it with corroborating information such as documentary evidence and interview. So I think it depends what other information is available in the context. But the DNA experts can feel free to answer in terms of the technical side.
So in terms of the technical side, ICMP is the best in the world. And when they, will come up with a report indicating the match and that likelihood that we talked about, the 99.99%, I think that the US government actually should and will defer to that. I think going to repeat the data then kind of defeats the purpose, right? To then say, oh, well, we need the parent to send this again. I do think they'll want some corroborating information, as Liz said, but no, I don't think it makes sense for the government to require the data be repeated. ICMP is the best in the world. They're better than any lab at doing this. They've done it for years and years. They are the best.
Yeah, and I think maybe a complication on with the question that's been posed is whether, if through DNA Bridge, for example, or through ICMP, a match were to be made, would the US government actually allow that reunification to happen without their own DNA testing to verify that claim? And I think we don't know the answer there because it hasn't been tested, but I think it brings up the good point that Liz made. And Liz, you made in your presentation, the difference between reunifying and reuniting, that the reuniting is the actual physical interaction and families are now back together. Whereas, if I understand right, the reunifying is to say, well, these two people belong to one another. They are genetically related, whether or not they reunite. And maybe the US government won't let them reunite without DNA testing on their own accord, but at least they can communicate with one another once they have found one another, once they have that connection. Am I explaining that correctly?
Yeah, I think that's a great explanation. I think it remains unclear the extent to which DNA Bridge or a response like it would be, actively cooperating with the U.S. government. We believe that it's very important that this work happens outside of any specific nation. And so I think it would be context dependent also in terms of whether a match was actually reported to the U.S. government. Under certain administrations, the DNA Bridge might make a match and the biological family in Guatemala might decide it's in partnership with legal counsel and psychological support that they're getting, might decide it's better that the U.S. government doesn't know that this match has been made.
It would be also rather contrary for the U.S. government to say that a match found by the non-government organizations using rapid DNA technology is invalid when they're using the very same technology supposedly to detect fraud.
Yeah, I agree. So what steps need to happen in our next 2 minutes? What steps need to happen to help to harness or spread the message to allow genetic data and DNA data to be used in these ways?
Sarah, I think the answer is in the question as you just posed it. We need to spread the message that it's time to harness DNA technology to reunify these families.
And the
And I
government
think we
needs to
also
step
need to
forward
have
and justify
support.
why they're not doing it.
And I think we also need to have outreach to NGOs, to our government, to Central American governments. We need to get buy-in that the steps that we believe will solve this problem are acceptable. So I think that we're ready to start that now.
And one last quick question. I'm often told that DNA testing is expensive. Is this a barrier that we need to think about, the cost, that the financial cost that could be a burden?
In terms of go ahead.
I think I could answer that, which is that the organizations that have developed the rapid DNA tests have offered to step up and provide the instrumentation reagents to do these types of reunifications.
And I would just add that maybe that's not the right question. We're not talking about the cost of DNA testing in the absence of other costs. We're talking about the costs of those compounding mental health, physical health problems, those compounding injuries that these children and their family members are experiencing, and what it's going to cost to repair that, to remedy that, to reestablish trust in the community, not just with those families, but with everyone across the world. So I think we need to think a little bit more broadly about the costs when we're asking about this. Of course, DNA testing isn't free. Even with the support of companies that are able to provide technologies, we do have to find some sort of long-term sustainable solution there. But it's not cost of DNA testing versus no cost. It's the unmeasured costs that these separations ongoing every day are creating that we need to consider.
I think we've hit the end of our period. I don't know if there's additional questions. I'm having trouble navigating the system a little bit, but I really look forward to hearing from those that attending this conference. You feel free to reach out to any of us or any of the other people on that long list of people that are a part of our initiative and our strategy and thinking through what is the best way to harness genetic data and move forward. So thank you very much, everyone.
Thank you.